Hey everyone, we are back. We are looking at Karen Reed's complaint in her civil suit. We left off, I'm going to share the PDF with you guys. We're going to read through it together. We left off kind of in the middle of looking at the facts of the case according to Karen Reed's team. The facts that they are going to end up having to prove what happened, they believe happened to John O'Keefe. So we got a little over 50% of the way through in part one. So I highly recommend checking that out if you haven't seen it yet. This is part two. We're going to finish those facts and we're going to look at the counts or the claims against the defendants. So let me share it with you guys and we will get started. Okay, so we finished right here. Now we're going into other aspects of the conflicted and corrupt investigation. I really like how this complaint is laid out. It really reads like a story. They create these headings and you kind of move through it chronologically and they piece everything together. Like I said, I think this complaint is very well written. Proctor's, Buchanan's, and MSP's investigation was rife with other examples of corruption and bias. For example, despite evidence that Brian Albert may have had video surveillance at the house, neither Proctor nor Buchanan nor any other member of the MSP issued subpoenas to Ring or any other home surveillance company. And no one questioned any other member of the Albert family about the presence of video monitoring. My bad there. Thought there's a typo. Really, they're just talking about Ring as a company. Proctor and the MSP also failed to track down other important witnesses and evidence. For example, Brian Loren, a town of Canton snowplow operator, turned out to be one of the most significant witnesses in the entire criminal trial. Yeah, I remember when this happened. Proctor and his colleagues never spoke to him during their investigation and only did so once Loren was interviewed by a separate law enforcement agency, FBI, and provided statements inconsistent with the MSP's narrative 18 months after Miss Reed was already indicted and awaiting trial. Specifically, Mr. Loren, I'm really hoping I'm saying his name right. Let me know if I'm not. Loren drove his snowplow by the house multiple times in the early morning hours of January 29th, including at 2:30 a.m. and 3:30 a.m. He reported that there was no body on the lawn at 34 Fairview, no cars on the street in front of the house at 2:30 a.m. Mr. Loren believes he would have seen a body had it been on the lawn where Mr. O'Keefe was found several hours later. Instead, the second time he drove by the house around 3:30 a.m., Mr. Loren saw a Ford Edge in front of the Alberts' home that had not been there an hour before, but which was then parked where Mr. O'Keefe's body was later found. Brian Albert drove a Ford Edge at that time. So I asked, I think in my last Lochran, sounds like Lochran. Lochran? Lauren? You've heard it? It's Lochran. You've heard it. I don't know if I've heard his name. I've only read it, so I'll call it Lochran if that's the case. But I find this interesting. So in the last video, I was like, what? How are they explaining the Ford Edge being moved to where John O'Keefe's body is? Like, how is that relevant? Because to me, I didn't catch any connection there. And somebody in the comments said, well, it's argued that it was moved there to hide them moving John O'Keefe's body out onto the lawn. Like hide what they were doing. And so if that's the allegation, that makes a little more sense that there was a Ford Edge there at the time. Okay, Lochran. Now I know. Thank you. Thank you, chat. Let's continue. However, the Ford Edge was gone by the time Miss Reed arrived to the house around 6 a.m. and in its place, she discovered Mr. O'Keefe's body. Proctor, Buchanan, and Tully never made any effort during the actual investigation to track down Mr. Lochran or any information related to the Ford Edge. Proctor also secretly made efforts to protect other Albert family members during the investigation who may also have had a role in Mr. O'Keefe's death. Now, again, we need to focus on the words that are being used here. Proctor also secretly, okay, this is all about intent. They're not saying that this is negligence. Because if you zoom out, and if you're not going to argue that there was actually a cover-up, there's a conspiracy, you're going to argue that Karen Reed actually did kill John O'Keefe, then that argument is that there was, in tandem with that, is that this is super negligent. It's just a bunch of negligence. They messed up. It's a terrible investigation. But you're going to argue that John O'Keefe was killed by Karen Reed. Now, of course, in this situation, they're pushing aside the negligence. They're saying, no, this is intentional. Proctor secretly made efforts to protect other Albert family members. And in line with this, that means that Karen Reed's team is going to have to argue the thoughts, the mental mindset of these individuals. How are you going to prove that Proctor secretly did this? How are you going to prove that this was intentional? Probably going to look at text messages, emails, all of that. But again, that's what they're going to have to bring to the table during this lawsuit. Witness Julie Nagel told Proctor that Colin Albert, Brian Albert's nephew, had been present at the house the night of January 28th, 29th, but Proctor omitted his name from his official summary of Miss Nagel's interview, even though he listed all others who had been present at the time at the house with Colin. When Miss Reed's attorneys filed a motion to obtain Proctor's notes, his handwritten memorization of the Julie Nagel interview mirrored almost exactly what was typed up in his police report, except for the words Colin Albert. So right there, they'll probably point to that and say, look, Colin Albert was there. It's in his notes, wasn't in the police report. We're going to point that back to Proctor secretly making efforts to protect other Albert family members. Why didn't the report mirror the interview? So that's what they're going to point to when trying to prove Proctor's mindset, that this wasn't negligence, this was a secret intentional action. Proctor's interactions with Kevin Albert, Brian Albert's brother, during the investigation also demonstrate his close relationship with the Albert family, as well as his propensity for violating MSP rules and Massachusetts criminal laws. Repeatedly, Proctor used his personal cell phone to speak with Kevin, a CPD officer, instead of official channels when he coordinated interviews of witnesses, even though CPD was recused from the investigation. Further, in the middle of Proctor's investigation in the summer of 2022, it was discovered that Proctor and Kevin Albert were out together drinking alcohol and driving in Proctor's cruiser on Cape Cod. At the end of the night, Kevin Albert forgot to bring home his gun and badge and left them in Proctor's cruiser. Their drinking and driving in Proctor's MSP vehicle violated both MSP policies as well as various Massachusetts criminal statutes, and further highlights the conflicted nature of MSP's investigation. Now here, you're looking at this and it's like, okay, how is this related to Karen Reed's case specifically? But what they're trying to highlight here is that Proctor has a history of not just negligence, but intentionally going against the MSP policies as well as Massachusetts criminal statutes. He's drinking and driving in his car, in his cruiser, with a friend, so again, adding to the idea that Proctor has the mindset, the motive to do these things. It's not just negligence, it's intentional. Moreover, because of their close relationship, Proctor, Buchanan, and Tully worked together with CPD in hiding certain videos from Karen Reed's criminal defense team. Specifically, upon information and belief, MPD and CPD collaborated to keep exculpatory surveillance videos from Karen Reed's criminal defense team in preparation for the first trial. Those videos captured Brian Higgins' activities in the CPD parking lot and inside the police station shortly after the physical altercation at the house that led to Mr. O'Keefe's death. They demonstrated that Higgins' statements about his post-house party activities on the night of Mr. O'Keefe's death were not accurate. Upon information and belief, CPD knew it had this evidence and worked with MSP to keep it from Miss Reed. Additionally, upon information and belief, CPD set its auto-delete function for saving certain surveillance videos from the Sally Port to 30 days, therefore assuring the immediate destruction of a likely additional exculpatory evidence. The 30-day auto-delete setting conflicts with the fact that CPD videos were shared with the defense over the course of 3 years. Therefore, either the setting was changed to prevent a defense expert from auditing the footage, which is when the 30-day setting was discovered, or the footage was obtained within 30 days of January 29th and then withheld from the defense. That's a huge accusation there. And I mean, that's just huge in general, that we are looking at, okay, did they take that video footage and hold it for 3 years? Or did they set it to auto delete to avoid the discovery? Either way you slice it, it looks bad. The indictments, trials, and aftermath. So this is going into more of Karen Reed's experience when it comes to the fact that she went through 2 criminal trials and it affected her, obviously. And that's going to add to what they're going to ask for in damages. Miss Reed was arrested on February 1st, 2022, pursuant to a criminal complaint charging her with manslaughter, among other charges. She was required to post $50,000 for bail, and the court imposed several other conditions of release, including loss of her driver's license and stay-away orders from the O'Keefe family and John O'Keefe III's home. It's interesting that they added the John O'Keefe's III's home in there. Miss Reed was later rearrested on January 9th of 2022 after being indicted for second-degree murder, manslaughter, and leaving the scene of an accident resulting in death. Her bail was set at $100,000 by the Norfolk County Superior Court. In February of 2023, her bail was reduced to $80,000 at the defense's request. Miss Reed was tried twice by the Commonwealth. The first trial started in April 2024 and ended on July 1st after the court ordered a mistrial because of a hung jury. So just setting out the history of all of this. On June 18th, 2025, following another nearly 2-month trial, Miss Reed was acquitted of all charges associated with the death of John O'Keefe, murder, manslaughter, and leaving the scene of an accident resulting in death. For the first time in 3.5 years, Karen Reed was able to leave court knowing that the forces aligned against her had failed to convince a jury to buy their deception. Beginning in January 2022, the defendant's actions have had profound effect on Miss Reed. She lost her employment and income. She lost her professorship. She lost her private health insurance. She lost her car and her driver's license. She lost her house. Her reputation, both personally and professionally, was utterly destroyed. She incurred multiple millions of dollars in debt for legal fees and additional millions in expert fees and costs. In addition, after being arrested twice, jailed twice, and tried twice, she has suffered years of intense stress and emotional harm, worried that she would be imprisoned for the rest of her natural life for a crime she did not commit. That paragraph right there, learning more about what Karen went through, what Reed went through as a result of all of this, it's really laying that out bare. Miss Reed suffers from both Crohn's disease and multiple sclerosis. Multiple sclerosis. Am I saying that right? As documented under seal with the criminal court, Miss Reed has undergone tens of surgeries to manage her illnesses prior to January 29th, 2022, and endured a blood infusion just months before Mr. O'Keefe's death. In the aftermath of the charges, 2 arrests, and during both trials, Miss Reed suffered a well-documented exacerbation of her symptoms amid the stress, anxiety, and emotional and physical impacts of being wrongfully accused of murder. While fighting for her freedom against a corrupt prosecution, Miss Reed underwent dozens upon dozens of documented medical procedures and treatments to attempt to address her health issues. The last 2 paragraphs, learning about what she went through, we can obviously kind of guess what it was like going through all of this, but then learning more about the medical experience she was having, her personal medical issues that were going at the same time as this, and undergoing dozens upon dozens of medical procedures and treatments while dealing with this, and the fact that she's on trial and she's accused of murder is not making her feel any better. It probably is. It's definitely exacerbating these illnesses. You don't get better when you're stressed, in fight or flight all the time. I just can't even imagine. The defendants concocted a plan, executed that plan, and framed an innocent woman, and they are now responsible for these extraordinary damages Miss Reed has suffered at their hands. MSP investigates and punishes Proctor, Buchanan, and Tully for their misconduct during the investigation. Proctor wrote more than 1/3 of the police reports in this case, testified at the stand grand jury 3 separate times, interviewed every member of the Albert and McCabe families, had possession, at least until March 14th, 2022, of all of John O'Keefe's clothing and all of the taillight pieces found broken from the housing, processed Mr. O'Keefe's Chevrolet Traverse the day after Miss Reed was arraigned, had access to and reviewed all the ring videos, had access to and reviewed the surveillance from CF McCarthy's, had possession of all of the CPD Sally Port and driveway videos, and numerous other critical investigative activities. So that's really laying out how involved Proctor was. And they have targeted Proctor throughout this complaint, and it makes sense given what we know with Proctor, with all the text messages, how he handled this case. So obviously they're going to really hone in on that. And they're doing it right now. and showing why they're honing in on it. Not just that he was corrupt, but also that he was incredibly involved in all of this. And yet, once evidence of Proctor's conflicts and lies became public, he was extricated from this case in an effort to hide him from the jury and sanitize the compromised investigation, while Miss Reed was forced to trial not once, but twice. Really emphasizing that she went twice. But I mean, because that's huge. Ultimately, Michael Proctor was relieved from duty and transferred out of the detective unit of the Norfolk County District Attorney's Office on July 7th, 2024, mere days after the conclusion of Miss Reed's first trial. Proctor was terminated from the MSP on March 19th, 2025. Upon a release from the district attorney of more implicating text messages from Proctor's phone on October 18th of 2025, Proctor officially ended his appeal with the Civil Service Commission. And I think we all remember when all that came out. It was huge. On September 23rd, 2024, an MSP internal affairs investigation found Yuri Buchanan failed to perform his supervisory duties in an ongoing investigation. On July 7th, 2025, Buchanan was transferred out of the NDAO detective unit and reassigned to an administrative role in another division. On October 18th, 2024, Brian Tully was disciplined and reassigned from SPDU and stripped of his detective designation. Tully was given special dispensation by Norfolk County District Attorney Michael Morrissey to continue detective work on the Reed case despite his demotion because of his behavior on this case. That is actually very odd. That is very odd why he would continue detective work on the Reed case when he was stripped of his detective designation because of the behavior on the case. Doesn't really make sense. Upon information and belief, MSP troopers David Diachico and Jeffrey Kotkowski were also disciplined for their misconduct associated with MSP's investigation of Miss Reed. Are you guys having fun listening to me try to pronounce all these last names? It doesn't help also that words, they're different depending on your region. Depending on if you're in the Northeast or the Pacific Northwest or the South, or trying to come up with town names. Town names or city names in the South, especially, it's like if you Maryville, Louisville. No, it's Merville. It's Louisville. This is a whole rant on my side, but I struggle with that. Okay, now we're getting into the counts. These are the claims. Count 1. Malicious prosecution under the Fourth Amendment. This is against Proctor, Buchanan, and Tully. So not all the defendants. They're listing out the specific defendants that counts against them. These are the 3. The preceding paragraphs are incorporated herein by reference. Proctor, Buchanan, and Tully violated Miss Reed's Fourth Amendment rights by engaging in malicious prosecution of Miss Reed by causing her to be seized pursuant to legal process unsupported by probable cause. The criminal proceedings against Miss Reed terminated in her favor when she was acquitted of murder, manslaughter, and leaving the scene of an accident with a death. So also right here, I just want to note this footnote here. After making presentment, Miss Reed will add counts against MSP for negligent training, supervision, and retention of MSP troopers, including Proctor, Buchanan, and Tully, and then also the town of Canton for negligent oversight of the investigation into Mr. O'Keefe's death and his own officers and facilities. So I said this in part 1, but the reason why MSP in the town of Canton are not named as defendant in this right now is because of a Massachusetts law that requires presentment. And so this complaint did say they will be added at a later date. So those are 2 other named defendants for this specific count. Proctor, Buchanan, and Tully caused Miss Reed to be seized without probable cause as described above, including but not limited to by leading, handling, and participating in the O'Keefe investigation, even though Proctor was conflicted due to personal relationships with various witnesses, suspects, and potential suspects, which conflict led to Miss Reed's unlawful treatment. Handling the investigation, even though Proctor had an extreme and personal negative bias towards Karen Reed, which bias led to Miss Reed's unlawful treatment. Violating MSP's rules, policies, and procedures in all aspects of the investigation. Planting, fabricating, and manipulating evidence, falsifying documents, preparing false affidavits, and committing perjury. Failing to secure evidence in the crime scene, obtain evidence timely, and appropriately interview suspects and investigate the Alberts, McCabes, or Higgins, and allowing them to destroy potentially exculpatory evidence. Failing to consider and present exculpatory evidence to prosecutors and the grand jury investigating Mr. O'Keefe's death, such as the evident dog bite injuries on Mr. O'Keefe's arm and evidence that his injuries were caused by an altercation and not a vehicle strike, such as the lack of lower body trauma. So these, I just want to point out, these are all things that Karen Reed's team is going to have to prove. And some of these are going to be easier to prove than others. For example, leading, handling, and participating in the O'Keefe investigation, even though Proctor was conflicted due to personal relationships with various witnesses, that's not going to be very hard to prove. We know that he had personal relationships with these witnesses. Okay, let's see. Handling the investigation, even though Proctor had an extreme and personal negative bias, not very hard to prove given the text messages that have already become public about Karen Reed and his opinions on her. But as we move down this, we see it's going to be a little harder to prove some of these things. So failing to, or let's see, this one. Planting, fabricating, and manipulating evidence, falsifying documents, preparing false affidavits, and committing perjury. That's going to be a little bit harder to prove because you're moving out of the negligence world and moving into the intentional world. And then you have to find motive. You have to find his intent and what he's thinking is in his mind. So you have to have evidence to support that. It's not that he just messed up and made a mistake by not, properly looking around John O'Keefe's body to find the taillight that they later found. It's not that he just made a mistake. It's the fact that he planted the taillight by his body at a later date, or where his body was at a later date, purposefully to try and frame Karen Reed and make it look like something happened that didn't actually happen. That's going to be a little bit harder. And I'm very interested to see how Karen Reed's team decides to prove that. Okay. Following her indictment by a grand jury, Miss Reed was rearrested without probable cause, forced to pay a $100,000 bond to be released from custody, and required to comply with numerous pre-trial release provisions. The post-arraignment deprivations of her liberty constitute seizures under the Fourth Amendment. Just checking the chat, as long as I can say garage. Okay. Those deprivations continued during Miss Reed's second trial, in part because of Proctor's false testimony at Miss Reed's first trial. Among other things, Proctor falsely testified that when he first saw the taillight on Miss Reed's car at Miss Reed's parents' house in Dighton, it had large pieces missing, and the shattered taillight displayed at the first trial, as photographed on February 1st of 2022, was in the same condition as on January 29th. That's something they're going to have to prove. He and Buchanan never touched any part of Miss Reed's vehicle when it was stored in the CPD Sallyport. He retrieved taillight pieces on subsequent searches at the Alberts home when he knew he had deposited or arranged for someone to deposit taillight pieces at the property. Again, they're going to have to prove all of this stuff. And in my opinion, it might be kind of hard to prove all of this. They are going off a lot of circumstantial evidence and then making inferences based on that circumstantial evidence. We'll see. Is it intent or negligence? Chris and Julie Albert were his loose acquaintances rather than friends, and his statements in sworn affidavits all claiming the Lexus was seized at 5:30 p.m. and that he arrived in Dighton at 4:30 p.m. were typos. Okay. Thus, Proctor, Buchanan, and Tully, acting under color of law, violated Miss Reed's Fourth Amendment rights against unreasonable searches and seizures. As a proximate result of this misconduct, Miss Reed was wrongfully prosecuted for Mr. O'Keefe's death and made to defend herself in 2 trials in the Superior Court of Norfolk County, resulting in the loss of employment, reputational damages, and millions of dollars of legal expenses, as well as serious emotional and physical distress and injury. In addition to award of damages for these harms, Miss Reed is entitled to her attorney's fees under 42 U.S.C. Section 1988, costs, interest, and punitive damages. Now we're going into count 2. So these counts right now they're federal claims related to her civil rights. We're going to move later on. They start bringing in state ones as well. Now, a reason why they're doing both federal and state is they're trying to join this with the wrongful death case that's going on right now in the state of Massachusetts. And so if they want that to happen and they don't want it to be moved into federal court, they're going to have state claims as well. So that comes a little bit later. Okay. Count 2. Supervisor liability. This is against Buchanan and Tully in their individual capacities. So these are against the supervisors. The preceding paragraphs are incorporated herein by reference. I'm just going to skip that one from that sentence from here on out. A supervisor is liable under 42 USC section 1983 when the supervisor supervises, trains, or hires a subordinate with deliberate indifference towards the possibility that the subordinate's deficient performance will result in deprivation of an individual's constitutional rights. Buchanan and Tully knew or should have known that there was a grave risk that Proctor would fail to investigate the Alberts, with whom he had a close personal relationship, which he had disclosed. They also knew or should have known that there was a grave risk Proctor would wrongly seek to have Miss Reed charged given the manifest bias evidenced in his text messages, which were sent to Buchanan, among others. So they were aware of this bias. They were aware of these text messages. Buchanan and Tully could have taken easily available steps to avoid a constitutionally deficient, malicious prosecution of Miss Reed. Those measures include, but are not limited to, 1. Replacing Proctor with an unbiased investigator that had no personal relationship with anyone involved in Mr. O'Keefe's death. 2. Safeguarding the crime scene and the physical evidence, including Mr. O'Keefe's clothing and 47 pieces of taillight material, to prevent anyone from planting, manufacturing, or manipulating evidence. 3. Initiating timely searches at the Alberts' house. And 4. Quickly seizing the cell phones and other forms of electronic evidence in the possession of the Alberts, the McCabes, and Higgins, which would have prevented their later manipulation and destruction. By not taking any of those measures, Buchanan and Tully permitted Proctor and Tully permitted Buchanan to violate Miss Reed's Fourth Amendment rights against unreasonable searches and seizures, and thus themselves violated Miss Reed's Fourth Amendment rights. In these ways and others, Buchanan's conduct constituted condonation of or acquiescence to Proctor's behavior or gross negligence amounting to deliberate indifference. In these ways and others, Tully's conduct constitutes condonation or of. Did I just read that? No. Okay. My bad. In these ways and others, Tully's conduct constitute condonation of or acquiescence to Buchanan's and Proctor's behavior or gross negligence amounting to deliberate indifference. So it's deliberate indifference. It's essentially saying it's akin to intent. As proximate results of their breaches, Miss Reed was wrongfully prosecuted for Mr. O'Keefe's death, resulting in the loss of employment, reputational damages, and millions of dollars of legal expenses, as well as serious emotional and physical distress and injury. It's going to kind of end. Each one of these counts kind of starts the same and ends the same. Count 3. Conspiracy to deprive Miss Reed of her Fourth Amendment rights. This is going to be against Proctor, Buchanan, Tully, the Alberts, the McCabes, and Higgins. So all the House defendants. Proctor, Buchanan, Tully, the Alberts, the McCabes, and Higgins shared a common design and acted in concert to frame Miss Reed for Mr. O'Keefe's death. There was a meeting of their minds. They shared a common design. They acted together to do this. They're going to have to prove that. As part of their concerted efforts and among their many other misrepresentations, the Alberts, McCabes, and Higgins agreed with each other to tell investigators that Mr. O'Keefe never entered the house, that they did not see Mr. O'Keefe in the house that night, that Miss Reed made inculpatory statements on the morning of January 29th. So again, they're going to have to prove this. Do you guys think that they're going to be able to prove this to a jury? Because at the end of this, they do ask, this is going to be seen by a jury. This is going to be in front of a jury. Do you think that they will successfully be able to prove this to the jury? When they made these statements, the House defendants did so only because they were aware that Proctor, Buchanan, and Tully would also act similarly by solely investigating Miss Reed. Proctor, Buchanan, and Tully knew or should have known that the statements made to them by the House defendants were false, and that obvious and easily obtainable evidence existed demonstrating Mr. O'Keefe went into the house where he was involved in a physical altercation during which he was beaten up, fell back, gashing his head, and attacked by a dog. Instead, because of their close personal and professional ties to the House defendants, Proctor, Buchanan, and Tully agreed with each other to use the House defendants' misrepresentations as the predicate for an implicit direction to conduct an investigation that solely targeted Miss Reed to the exclusion of anyone and everyone else. I flipped those. Of everyone and anyone else. I kind of read ahead in my mind when I'm talking, and That's what happens sometimes. In furtherance of this plan, among other unlawful conduct, Proctor, Buchanan, and Tully agreed to continue to handle the investigation even though they had personal relationships with suspects in the murder, which led to unlawful and favorable treatment of potential suspects, to continue to handle the investigation even though they had biases against investigating the House defendants because of the House defendants' ties to law enforcement. I think that'll probably be easy to prove. To continue to handle the investigation even though they had exhibited an extreme and personal negative bias towards Karen Reed. Probably going to be easy to prove based on the text messages we've seen so far. And more is probably going to come out as this civil case continues. More is going to come out and is going to be seen in the civil case than in the criminal case, though there still may be some control of that as well. To violate rules, policies, and procedures in all aspects of the investigation, to plant, manufacture, and manipulate evidence, falsify documents, and commit perjury. That's going to be a little bit harder to prove. To not secure evidence in the crime scene, very easy to prove. To not investigate and obtain available evidence or timely and appropriately interview suspects, and to not investigate the Alberts, McCabes, or Higgins. The McCabes and Alberts coordinated their efforts through text messages, phone calls, and conversations. Higgins and Brian Albert coordinated their efforts through telephone calls and texts on their phones, which were later destroyed or discarded, which is that whole part of it is crazy to me. Finally, Proctor, Buchanan, and Tully coordinated with the Alberts and McCabes through Proctor's sister, Courtney, who communicated frequently with Julie Albert. Acting pursuant to the plan, Proctor and Buchanan interviewed the McCabes and Brian Albert in a cursory manner, and all at the same location, midday on January 29th, and Nicole Albert on February 3rd. Proctor and Buchanan only interviewed Higgins once at his attorney's home and did not secure or search his phone or search for communications between him, the Alberts, and the McCabes. Proctor and Buchanan did not search the Alberts' phones or homes where there was likely evidence of Mr. O'Keefe's murder. Brian Albert and Higgins destroyed or discarded their phones, destroying evidence of the murder and cover-up. As a result of the conspiracy between and among them, Proctor, Buchanan, and Tully never investigated the House defendants, and instead Miss Reed was wrongfully arrested and prosecuted in violation of her Fourth Amendment rights. Proctor, Buchanan, Tully, and the House defendants acted in unison and had a peculiar power of coercion over Miss Reed because Proctor, Buchanan, and Tully were the state police employees investigating Mr. O'Keefe's murder, and the House defendants were able to direct that investigation solely towards Miss Reed because of their personal and professional connections to Proctor, Buchanan, and Tully, and their superior knowledge of police and criminal investigations as a result of their own work in and connection to law enforcement. So they were in a position of power. They had superior knowledge of police and criminal investigations, and then they had all these personal and professional relationships that were crossing. And the Karen Reed's team right now is saying, look at this web. In my brain, it kind of looks like a web of all these individuals and all these connections, and they have superior knowledge. They are involved with the police. They understand criminal investigations, and they conspired and worked together to work against Karen Reed and do an entire cover-up and to frame her. Count 4. Now we're getting into the state claims. Again, they're trying to bring this in with the wrongful death suit that's currently in the state of Massachusetts, and in order to do that properly, they're going to have some state claims here, state counts, and also this just makes sense in general. Massachusetts civil rights laws, MCRA, it is applicable. This is against all of them, all the defendants. Except for it, there is no, I want to say there is no footnote that mentions it's going to be the town of Canton or the other government entity. And so my guess is those individuals are not going to be named as defendants in this specific count. But I'm not positive. Maybe they forgot, but I don't think that's going to be the case. Proctor, Buchanan, Tully, and the House defendants interfered or attempted to interfere with Miss Reed's exercise or enjoyment of her rights under the federal and Commonwealth constitutions and laws, through threats, intimidation, or coercion. Among other acts, by manufacturing and planting evidence, not securing the crime scene, not searching the Alberts' home or the Alberts and Higgins' phones, and ignoring exculpatory evidence such as the dog bite injuries and lack of injuries consistent with a vehicle strike, Proctor and Buchanan caused Miss Reed's wrongful indictment, arrest, and prosecution, and thereby interfered and attempted to interfere with her rights under the Fourth Amendment to the United States Constitution and Article 14 of the Massachusetts Declaration of Rights. By falsely representing that Mr. O'Keefe never entered the Albert house and by relocating his body to the location on the Alberts' property where they would claim Miss Reed dropped off Mr. O'Keefe, the Alberts, the McCabes, and Higgins caused Miss Reed wrongful indictment, arrest, and prosecution. Brian Albert and Brian Higgins also caused Miss Reed's wrongful indictment, arrest, and prosecution by destroying or discarding their phones, eliminating exculpatory evidence. The House defendants thereby interfered and attempted to interfere with Miss Reed's rights under the Fourth Amendment to the United States Constitution and Article 14 of the Massachusetts Declaration of Rights. Miss Reed's wrongful indictment, arrest, and prosecution were intrinsically coercive under Massachusetts law. Moreover, the House defendants and Proctor's, Buchanan's, and Tully's conduct amounted to threats, intimidation, and coercion designed to force Miss Reed to give up her defense and plead guilty to a crime she did not commit. That's a huge accusation. The conduct amounted to, they were threats, intimidation, and coercion designed, so intentionally made, to force Miss Reed to just give up and plead guilty to a crime that she did not commit. They're going to have to prove that that is what happened, but that is a huge accusation there. And then, as a proximate result of defendants' actions, Miss Reed was wrongfully prosecuted for Mr. O'Keefe's death, resulting in the loss of employment, reputational damages, millions of dollars of legal expenses, the same kind of ending here. Also, if you're currently watching right now, I would be eternally grateful for you to just hit the like button. That would really help me out. And then I'll just continue on. I'll keep moving on, but please hit the like button, help me out. Okay, count 5, common law malicious prosecution. I talked about this a little bit more in part 1. Yeah, they wanted a plea deal. Yeah, that's what they're arguing here. They wanted her to just plead guilty because she was just, intimidated. There were threats. She was up against individuals who were in the police department. They were in law enforcement. They had more knowledge, all of that. And they wanted her to plead out because the argument here, the accusation, the allegation here is that if she went to trial, what would happen is exactly what's happening right now, is that everything would blow open, wide open, and we would be in the exact situation that we're in right now. That's what they're arguing right here. Count 5, common law malicious prosecution. Yep, against all the House defendants. By manufacturing and planting evidence, not securing the crime scene, not searching the Alberts' home or the Alberts and Higgins' phones, and ignoring exculpatory evidence such as Mr. O'Keefe's dog bite injuries and lack of injuries consistent with a vehicle strike, Proctor, Buchanan, and Tully caused Miss Reed's indictment, arrest, and prosecution. Welcome to everyone to the couple individuals who just joined the live. I'm keeping an eye on the chat a little bit. I'm trying not to get too distracted. Miss Reed's indictment, arrest, and prosecution occurred without probable cause because they were based on false, manufactured, manipulated, and planted evidence, and because Proctor, Buchanan, and Tully ignored exculpatory evidence and allowed potentially exculpatory evidence to be destroyed. These criminal proceedings were instituted with malice, as evidenced by Proctor's, Buchanan's, and Tully's knowledge that it was based on false evidence, Proctor's, Buchanan's, and Tully's bias and ill will towards Miss Reed, and for the improper purpose to protect Proctor's friends and acquaintances, the Alberts. The criminal proceedings terminated in Miss Reed's favor when she was acquitted of murder, manslaughter, and leaving the scene of an accident with a death. By falsely representing that Mr. O'Keefe never entered the Albert house and by relocating his body to the location on the Albert's property where Jennifer McCabe would claim Miss Reed dropped Mr. O'Keefe, Brian and Nicole Albert, the McCabes, and Higgins caused Miss Reed's wrongful indictment, arrest, and prosecution. Brian Albert and Brian Higgins also caused Miss Reed's wrongful indictment, arrest, and prosecution by destroying or discarding their phones, eliminating exculpatory evidence. Every single time I read about the fact that they just got rid of their phones, I'm just repeatedly what? That's crazy. Okay, I'm checking the chat again. Okay. And just talking about, the result of the loss of employment, it's the same kind of ending for each count. Count 6, intentional infliction of emotional distress. This is against all the House defendants. The preceding paragraphs are incorporated herein by reference. by manufacturing and planting evidence, not securing the crime scene, not searching the Alberts' home or the Alberts and Higgins' phones, and ignoring exculpatory evidence such as Mr. O'Keefe's dog bite injuries and lack of injuries consistent with a vehicle strike, Proctor, Buchanan, and Tully caused Miss Reed's indictment, arrest, and prosecution. Again, we're kind of hearing the same thing over and over again. That's the law. That when you write these things, it's dotting all your I's, crossing all your T's. You got to be really, you have to make it very obvious what you're arguing here. By falsely representing that Mr. O'Keefe never entered the Albert house, and by relocating his body to the location on the Albert property where Jennifer McCabe claimed Miss Reed dropped Mr. O'Keefe and the Alberts, the McCabes, and Higgins, caused Miss Reed's wrongful indictment, arrest, and prosecution of Miss Reed. Brian Albert and Brian Higgins also caused Miss Reed's wrongful indictment, arrest, and prosecution by destroying their phones. The defendants knew or should have known their conduct would cause Miss Reed emotional distress, since it would lead to her prosecution for murder and other crimes. And the conduct did cause and is causing Miss Reed severe emotional and physical distress. So if they're able to prove everything that we have been reading, if they're able to prove that there was a conspiracy, this was a cover-up, that they framed Karen Reed, then the IIED, intentional infliction of emotional distress, that count is going to be very easy to prove. Because it's like, okay, yeah, obviously, if you're going to frame somebody, and if you are going to cover all of this up, and you're going to use your positions of power to try and get somebody convicted of murder who did not commit murder, intentional infliction of emotional distress is just going to come with the territory. But to get to this, they're going to have to prove all the other things that I mentioned before, and that's going to be a little bit harder. Count 7, civil conspiracy against all the House defendants. Proctor, Buchanan, Tully, the Alberts, the McCabes, and Higgins share common design and acted in concert to frame Miss Reed for Mr. O'Keefe's death. As part of their concerted efforts, and among their many other misrepresentations, the Alberts, McCabes, and Higgins agreed with each other to tell investigators that Mr. O'Keefe never entered the house, that they did not see Mr. O'Keefe in the house that night, and that Miss Reed made inculpatory statements on the morning of January 29th. They agreed with each other to tell the investigators. They worked together. They conspired together to do this. They're going to have to prove that, though. When they made these statements, the House defendants did so only because they were aware that Proctor, Buchanan, and Tully would also act similarly by solely investigating Miss Reed. So now tying in Proctor, Buchanan, and Tully, they will act similarly. Proctor, Buchanan, and Tully knew or should have known that the statements made to them by the House defendants were false, and that obvious and easily obtainable evidence existed demonstrating Mr. O'Keefe went into the house where he was involved in a physical altercation during which he was beaten up, fell back, gashing his head, and attacked by a dog. That's the story. That is what they're saying happened to Mr. O'Keefe. Instead, because of their close personal and professional ties to the House defendants, Proctor, Buchanan, and Tully agreed with each other to use the House defendants' misrepresentations as the predicate for an implicit direction to conduct an investigation that solely targeted Miss Reed to the exclusion of everyone and anyone else. In furtherance of the conspiracy, Proctor, Tully, and Buchanan agreed to fabricate, plant, and manipulate evidence purporting to show that Miss Reed's vehicle hit Mr. O'Keefe. Pursuant to their plan, Proctor, Buchanan, and Tully carried out multiple overt acts, including damaging the taillight on Miss Reed's vehicle while it was in the town of Canton Sallyport, not securing the crime scene, and depositing taillight pieces on January 29th, prior to the MSP CERT team's arrival on site. In addition, Proctor deposited some of the broken taillight pieces on Mr. O'Keefe's clothing while the clothing was in his unprotected custody. Proctor also deposited glass, alleging to have been from a cocktail glass, on the bumper of Miss Reed's Lexus SUV sometime prior to the vehicle processing by MSPCL on February 1st of 2022. Because that's crazy. That one also gets me every time, because you're going to argue. So I'm saying the defense. In this situation, the defense is going to argue that there were cocktail glass pieces on the bumper of Miss Reed's Lexus, that the Lexus got towed, ended up in the Sallyport, and somehow all of those cocktail glasses, and it was snowing, all of that stayed on the bumper. That's going to be a hard one for the defense. Another part of the conspiracy was to take coordinated steps to ignore and destroy potentially exculpatory evidence that pointed to other suspects like the Alberts and Higgins. The McCabes, the Alberts, and Higgins coordinated through text messages, phone calls, and on information and belief conversations. Higgins and Brian Albert coordinated through telephone calls and on information and belief text on their phones, which were later destroyed or discarded. Finally, Proctor coordinated with the Alberts and McCabes, though through his sister, Courtney, who spoke frequently with Julie Albert. Acting pursuant to the plan, Proctor and Buchanan interviewed the McCabes and Brian Albert in a cursory manner the morning of January 29th and Nicole Albert on February 3rd. All told the same false story that Mr. O'Keefe never entered the Alberts' house. Proctor, Buchanan, and Tully also only interviewed Higgins once with his attorney at his attorney's home and did not secure or search Higgins' phone or search for communications between him, the Alberts, and the McCabes. Pursuant to the coordinated plan, Proctor, Buchanan, and Tully also did not search the Alberts' phone or home where there was likely evidence of O'Keefe's murder. Further, Brian Albert and Higgins destroyed or discarded their phones, destroying evidence of the murder and cover-up. Following Mr. O'Keefe's death, among other acts, the McCabes and Alberts agreed to make it look like Mr. O'Keefe died due to exposure after being hit by Miss Reed's car. As part of this common plan, Brian Alberts and Higgins, both law enforcement officers familiar with investigations, communicated at 2:22 a.m. on January 29th after Higgins left the house. Shortly thereafter, as part of the plan, Jennifer McCabe deleted a Google search at 2:27 a.m. on January 29th for how long it takes a person to die in the cold. One or more of them then relocated Mr. O'Keefe's body and deposited it in front of the Alberts' house, where Jennifer McCabe claimed Miss Reed had dropped Mr. O'Keefe off earlier. The McCabes and Alberts then coordinated what they would say to the police, all of them falsely telling investigators that Mr. O'Keefe never entered the house. Yeah, another aspect of this case that I find so interesting is the butt dial defense. The butt dial idea. The fact that all these phone calls among all these people were just butt dials. Why were the butt dials only among each other? If you are somebody who just for some weird reason butt dials a lot of people, shouldn't you have butt dials to like other people? I wonder if they're gonna like show that in the case. So the defense is gonna be like, well, actually, this person butt dials like people all the time. Look at all this evidence. They've been butt dialing people for the last 5 years. How are you gonna argue that? Proctor, Buchanan, Tully, and the House defendants acted in unison and had a peculiar power of cohesion over Miss Reed because Proctor, Buchanan, and Tully were the state police employees investigating Mr. O'Keefe's murder, and the House defendants were able to direct that investigation solely towards Miss Reed because of their personal and professional connections to Proctor, Buchanan, and Tully and their superior knowledge of police and criminal investigations as a result of their own work in and connection to the law enforcement. Answered butt dials. Yeah, also answered butt dials. So the butt is also answering. The butt dials and the other butt answers. What? Proctor's, Buchanan's, Tully's, and the House defendants' conduct described herein were unlawful and tortious. Among other things, they constitute intentional infliction of emotional distress, negligence, common law malicious prosecution, and violations of Miss Reed's rights pursuant to the United States Constitution and the Massachusetts Declaration of Rights. Yeah. Reading the chat. I would also like to see if it's just normal for them to be butt dialing. Again, I don't understand how you butt dial with iPhones or Androids. I just don't get it. Don't you have a lock screen? I think the only thing you can butt dial is emergency services. Unless you just leave your phone open all the time and it never shuts off, which then your phone's going to die all the time. Your phone's not even going to be alive at 2 in the morning at that point, if that's the life you're living. Dangerous life, leaving your phone on like that. Okay. Jury demand. Miss Reed respectfully requests a jury trial on all matters so triable. Prayer for relief. Enter judgment in her favor and against each relevant defendant on each count of this complaint. Award her damages in an amount to be calculated at trial, along with pre- and post-judgment interest, costs, and expenses. Award her reasonable attorney fees incurred in connection with this litigation pursuant to 42 U.S.C. Section 1988 and other applicable statute or law, and grant her such relief as the court deems equitable. And then it is signed by our attorneys. We have the famous Alan Jackson right here, as we all know who he is. I mean, we know he helped write this. I read this in Alan Jackson's voice at this point. But that's it. That is the complaint. I'm very interested to see what happens next. Here, let's move over here. I am very interested to see where we go next, what's going to come out, how the defense is going to respond to this, how Karen Reed and her team are going to argue some of these counts or some of these facts. How are you going to argue, the intentional aspect of this, the motive? How are you going to get into the mind of these individuals? What further text messages, emails, and stuff are going to come forth that hopefully we all get to read that are going to support their story here, that Mr. O'Keefe did in fact go into the house or the garage, that there was an altercation, that there was a fight, that he fell backwards, cracked his head, and that a dog attacked him. And then after that, that all the individuals involved here, all these House defendants, conspired against Karen Reed. I'm very interested to see that. So I will keep you guys. It will be an episode, that's for sure. It'll be an entire docuseries. We're going to have so many episodes. It's going to be a trilogy, 3 movies about this. No, but anyways, I'm going to keep you guys updated on all of this as we move forward. I just want to thank everyone who was here, who's still here, who watched the whole thing. I really want to thank the people in the chat. I want to thank everyone who's liking. Please like the video. And I want to thank the members who have, become members of my channel. That kind of support helps me so much. I have not seen pics of the garage yet. I'm going to look into that for sure. But your support means the world to me. It helps me continue to do what I'm doing here every day, doing all the research and reporting it back to you guys. So until next time, I hope you guys stay safe and stay curious. I'm excited to see you guys again. Live was really fun. This is my second one ever. I'm going to do it more often. Anyways, see you later. Bye.